Restaurant bar liability for intoxicated patrons who harm third parties at common law. Michael Smith, Law 2005, Johnson of Wales. In this presentation, I'll be talking about Common Law to Dram Shop Law Act with an explanation of dram shop law, statistics, drunk driving violations, and third-party liability. Americans love their alcohol in all its glory. The United States Center for Disease Control reports that 50% of American adults consider themselves regular drinkers. In 2016 alone, there were 10,500 people who died in alcohol-impaired driving crashes, according to a National Highway Traffic Safety Administration report published in 2017. New York has responded by passing legislation targeting alcohol sellers who provide alcohol to visibly intoxicated adults and social hosts who knowingly permit minors to drink. This article reprised civil liability in New York for wrongfully supplying alcohol to the intoxicated and underage drinker. New York's first Dram Shop Act was enacted in 1873, and the Dram Shop statute has been amended and supplemented multiple times since then. New York's Dram Shop Law. If you're injured by an intoxicated person, you can bring claim for damages against any person who caused or contributed to their intoxication by unlawfully selling liquor to the intoxicated person. In New York, claims are regularly brought by injured third parties when alcohol is consumed in homes or public taverns. New York's Dram Shop Act affords a person who is injured as a result of another's intoxication and cause of action against the party that unlawfully sold, provided, assisted in providing the alcohol to the intoxicated person. Recently, courts in New York have been limiting the extent of personal liability for such injuries by upholding stricter rules on the public taverns and commercial establishments that serve alcohol. The first drunk driving laws were passed in New York in 1910, a decade after the mass production of automobiles began in the U.S. Soon after, alcohol blood content levels were introduced as a standard, and laws in the 1930s and 40s set the bar at 0.5% and is now 0.8%. It is illegal for business to sell alcohol to visibly intoxicated persons. Ultimately, where such person is visibly intoxicated is a question of fact. Expert eyewitness testimony can be afforded to provide visibly intoxication, but proof of intoxication by high blood alcohol content alone is insufficient to draw references as a person's demeanor at the time the person was served alcohol. Types of alcohol-related violations in New York State. Driving while intoxicated, DWI, is 0.08 blood alcohol content or higher. Driving aggravated while intoxicated is 0.18 BAC or higher. Zero tolerance is for a driver less than 21 years of age who drives with 0.02 BAC to 0.07 BAC, violates the zero tolerance law. New York is one of 30 states which have enacted dram shop laws, which impose civil liability on third parties for aiding and abetting the intoxication of an individual who causes injury by virtue of his or her intoxication. In the common law, there was generally no liability on the tavern owner who piled the intoxication with liquor. The drunkard was deemed to be the proximate cause of his own inebriation, and the havoc and harm he caused was deemed to be unforeseeable. at least to the tavern keeper. And that was my presentation on restaurant bar liability for intoxicated patrons who harm third parties at common law through today. Thank you very much. And this is all cited work for my presentation.